Next on our list is Michael Nowacki.
Good afternoon, Senator Coleman, Representative Fox as chair, and the other distinguished members of this panel. You have all received a letter from me on the first day of the opening of this legislature. And what is remarkable to me is that at last count there are only 16 members of the 45 members, and neither of my representatives present from the town of New Canaan at this hearing. It speaks volumes about the responsiveness of this group to the citizens of this state. As way of background, I have declared myself in the state of Connecticut as a private attorney general of this state. And the reason why is that 2.5 years ago, a family court judge in Stamford, Connecticut, Judge Mary Louise Schofield, without a hearing, on December the 2nd of 2009, stripped me of my custody rights of our two children, who were at the time 15 and 13 years old, without a hearing. I had a joint legal and physical custody contract that was approved as an order of the court on June the 29th of 2005. I dared to challenge the authority of a judge who I filed a judicial grievance against, 3 judges in Stamford, for hiding assets in a division of UBS in Stamford on my ex-wife's fiscal affidavit sworn in the court of law in the state of Connecticut. I took on those judges for hiding foreign assets in this state. And 8 days later, without a hearing, my children were taken away from me without a hearing. 5 years after, I had joint legal and physical custody of those 2 children. The court appointed an attorney for my 2 children, whose name was Veronica Reich, who works for a law firm in Shelton, Connecticut, called By Pollock, Blue Weiss, and Mulcahy. That lawyer never spoke to my children about filing an ex parte motion on December the 2nd of 2009 that resulted in the stripping of my custody rights without a hearing. Our children are entitled to the same representation defined by case law in the state of Connecticut as an unimpaired adult. Our children in this state have been stripped of their rights to the love, the care, and the devotion of parents everywhere. And by the way, I'm not stopping at 3 minutes. You're going to listen. You're going to listen. Because...
Mr. Nowacki, we'll grant you the courtesy. You're speaking regarding a judge that is not on our agenda for today.
About the processes of this state as it relates to the Judicial Review
We were granting you a courtesy to address us.
Sir, and I'm addressing the subject.
Don't take advantage of the courtesy.
I'm taking advantage of the opportunity to discuss the absolute lack of supervision of this committee, of your responsibilities underneath Connecticut General Statute 51-14.
Well, my point to you is,
that
I am the chairman of this committee presiding at this hearing. You're not going to tell me what you're going to do with respect to this committee. That's just a fact.
We are citizens, sir, of this state, and that our representatives,
Mr. Nowacki,
sir, I sent you a letter.
Please appreciate that we are accommodating you. Please return the courtesy that we're extending to you.
Sir, I sent you a letter
that we're extending to
I
you.
sent 45 letters to the opening day of this Judiciary Committee. I hand-delivered them here. I have not heard from one of you. Not one, sir. You want to talk about disrespect? You just got your schooling. We are tired in this state of this legislature ignoring the citizens of this state and your responsibility, sir, to have upheld public hearings on Connecticut General Statute 51-14. As a lawyer, sir, you have a responsibility. As a public servant, sir, you have a responsibility to uphold the laws of this state. This committee has engaged in a seditious corruption, taking away our rights as citizens to have had public hearings for the last 43 years. If you read the Office of Legislative Research document issued by an intern by the name of Jillian Redding on the date of March the 27th of 2009, you would realize that the Chief Judge of the Supreme Court of this state in 1969 determined that there would no longer be input from the Judicial Committee sitting right here before those judges could pass their own rules of practice. Each of you who have served in this committee, who have served as lawyers before you became judges, who allowed this process for judicial self-empowerment to occur in this state, you have engaged in the most seditious conspiracy to take away the rights of citizens of any state in this country. The Connecticut Practice Book is the single largest document of self-empowerment rules that exists in any state in the United States. All of you have a responsibility to the citizens of this state to have done your job. You get paid for this service. You are not just here as the chair of the committee. You are a citizen, responsible and paid, and have taken an oath of office which you, sir, have not upheld. I contacted this committee back in June with a 40-page letter about this issue of self-empowerment that occurred yet once again at the May 31st Rules Committee meeting of this state. I saw it. I spoke at the Supreme Court that day, sir. I delivered testimony there, along with 700 pages of documents that were given to the members of the committee that day about the subject of taking away habeas corpus rights in this country, which you, sir, allowed to happen. There are only two conditions in the Constitution of the United States that permit the taking of a habeas corpus right, and they are governed by the President of this country. You have engaged in taking away citizens' rights, and you passed and allowed that committee to pass a practice book rule that allows a judge to take away the rights of citizens in this state. And you, sir, are the committee chairman. You let it happen. So don't scold me about respect, because the respect is for the law, and
you're
the
trying
law.
my patience.
You know what? The law says, sir, that you were to conduct public hearings in this committee room. That is what Connecticut General Statute 51-14 says, and it has not happened. You, sir, have broken the law. Okay? You have broken the law. You have broken your oath of office, sir. And that we, our citizens, are not going to tolerate it any longer.
I think you're out of order.
Excuse me, sir?
I think you're out of order.
No, you're out of order because you have failed to respond to the citizens of this state.
The bell has
let me tell you what's happening. What's going to happen on Monday, sir? You are going to be sued in federal court, all right, for your role
to let you go
in
on
abusing your
or not go on.
responsibilities.
And
Okay.
I'm exercising that discretion.
You can exercise your discretion, sir, all you want. But on Monday in the U.S. District Court, you will be served with a federal lawsuit for your role, sir, in the supervision of, and you bet,
to do or not to do.
and we are going to take on this state for the
Officer, would you
seditious
please remove
conspiracy
this
that you've
gentleman?
engaged in. Okay? We're tired of it. Okay? Listen to the citizens for a change. You might learn something. I'm taking my best. Okay.
Mr. Nowacki, you forgot your photograph.
Thank you, sir. Listen.
Giuseppe Massano is next.
breather. I don't think the marshals will be necessary on my testimony. However,